Welcome to Washington Legal Foundation's webinar. My name is Glenn Lammi. I am Executive Director and Vice President for Legal Studies at the Foundation. Those of you not familiar with the Foundation, we are in our 48th year of free enterprise advocacy and education through the filing of amicus briefs in the state and federal courts, regulatory comments, and from our Legal Studies Division, which I run, programs such as this, publications, blog, etc. Our website's wlf.org. If you want to spend some time on that afterwards, that'd be great. So this is the sixth in the Tech in the Court series that WLF is presenting in partnership with TechFreedom, and this is our first this year. For those of you not familiar with TechFreedom, it's a nonprofit, nonpartisan technology think tank launched in 2011, so it's in its teenager stage right now. The organization seeks to advance public policy that makes experimentation, entrepreneurship, and investment possible, and thus unleashes the ultimate resource, human ingenuity, which I just love that tagline. So 3 days into the second Trump administration, the president issued Executive Order 14179, which rescinded the Biden administration's order on artificial intelligence and underscored the need to develop a regulatory framework that fosters American leadership in that technology while also balancing responsible management of possible risks. 2 weeks later, the Office of Science and Technology Policy asked for public comment on a federal AI action plan. So we've gathered 3 experts in this field today from fellow nonprofit policy groups to discuss the major issues raised in there and other comments. They also address the question that has animated calls for controls at the state and federal levels in the past: is AI actually unregulated? Introduce our speakers. First, Neil Chilson, head of AI policy at the Abundance Institute. He's a lawyer, computer scientist, and author of a really fantastic book, Getting Out of Control: Emergent Leadership in a Complex World. Neil served as the chief technologist at the Federal Trade Commission and as an attorney advisor to acting FTC chairman Maureen Ohlhausen. Andy Jung is associate counsel at TechFreedom. He started as an intern at TechFreedom while attending the Antonin Scalia Law School, where he graduated in 2021. Prior to law school, Andy worked for a software as service startup company where he became interested in legal issues like privacy and online speech. Finishing out our panel here is Kristian Stout, who's Director of Innovation Policy at the International Center for Law and Economics. He's been a fellow at the Internet Law and Policy Foundry, as well as the Eagleton Institute of Politics. Before practicing law, Kristian worked as a technology entrepreneur and a lecturer in computer science department at the Rutgers University. Please be aware that we are recording this. If you have any questions, please use the Q&A function in the Zoom webinar. And if by chance you're watching this as a recording on YouTube, please hit those like and subscribe buttons. All right, let's get started off with a question for Andy. So can you give us a brief description of the origins of this AI action plan and how the outlines of this plan differ from the approach of the Biden administration reflected in its executive order?
Sure, happy to. So I'll start by answering that question with a quick history lesson on US AI policy. So in October 2023, Biden released his executive order on safe, secure, and trustworthy development and use of artificial intelligence. As you can tell by the title of that executive order, the focus was really on safety, privacy, protecting civil rights and civil liberties, those sorts of issues. However, the executive order also focused on, is actually the second principle, was to promote responsible innovation, competition, and collaboration for AI in the US. So now turning to the Trump administration, they've turned away from this focus on safety for the most part. However, the Trump administration is consistent and continuing to focus on these themes of innovation and competition. So in January 2025, Trump released his executive order on removing barriers to American leadership in artificial intelligence. That revoked the Biden EO, and it kicked off the process for this AI action plan. So a month later, the Office of Science and Technology released a request for information on the development of an AI action plan, and it stated 2 goals. The two goals of the AI action plan are to define policy actions needed to sustain and enhance America's AI dominance, and number 2, to ensure that unnecessarily burdensome requirements do not hamper private sector AI innovation. So right there, you really see the emphasis from the Trump administration more on innovation and development and less of a focus on safety issues related to AI.
So as it indicated in the Biden EO and in our title, those concerned with AI's rapid emergence have developed this narrative that AI is unregulated. Andy, can you play Mythbuster for us?
Yeah, so in April 2023, so that was a lifetime ago in terms of AI policy, FTC Commissioner Bedoya observed that it's a myth that AI is unregulated. And that's even more true now than it was 2 years ago. These days, the FTC's go-to line is that there is no AI exemption from the laws on the books. I think that sums it up nicely. Existing laws apply to artificial intelligence. So, for example, discriminating against a potential tenant is illegal, regardless of whether you use AI or not. And on top of that, in recent years, we've seen a wave of state laws and federal laws and enforcement actions being brought against AI companies. So I think the FTC really nailed it. The laws on the books apply to AI, and it's just simply not true that AI is unregulated. You hear that less and less these days, but it's important to keep dispelling that myth, I think.
So the term artificial intelligence is used in discussions about policy and more generally in a very umbrella fashion, but the technology is really far from homogeneous. Kristian, what risks exist in the regulatory space if government treats AI as being that way homogeneous?
Yeah, that's a great question then. The first thing I would say, just to elaborate on the point you're making there, is when we hear about AI, what we're really hearing frequently are marketing and investor hype terms. Not to say that there's not a good reason to want to be hyped up about investing in the AI space, but investors don't go and invest in AI. They invest in particular implementations of the mathematics that we generally call artificial intelligence. Even within that in that sphere, there are many different techniques for applying machine learning and neural networks and different kinds of artificial intelligence techniques to solve particular problems. So we risk as policy commenters and policymakers, we risk being very imprecise in our definitions and missing our targets if we don't make very clear that you really can't regulate AI. You have to regulate particular uses of it in particular ways that complicate the existing regulatory apparatus. So the problems that flow from having too large a concept of what AI is or treating it as a homogeneous technology, one would be regulatory overbreadth. So if you treat AI as homogeneous, this is going to risk imposing inappropriate regulations across fundamentally different technologies. So in some cases, you're going to overregulate things that are really not a concern. And in other cases, you're going to create a regulatory framework that's trying to capture the field, this non-existent field, and you're going to miss things where you genuinely might need modifications to existing law and policy where AI maybe complicates enforcement. So your view will both be under-inclusive and over-inclusive, or risks being under-inclusive and over-inclusive. Outside of that, I think it's very easy to understand how this would stifle innovation. So if you try to regulate AI and you create very broad regulatory definitions about what is and is not AI, and anybody who falls outside of those definitions first will have to risk possible legal sanction if they're doing something that kind of fits but kind of doesn't. So you're going to be chilling innovation at the margins of people who are trying to play in this space but maybe don't fit into your current concept of what AI is for regulatory purposes. But more broadly, even if you have companies that fit well within the frameworks you develop, you're going to be creating excessive compliance costs just to be able to work within that field, which is naturally going to favor larger incumbents over smaller new entrants. You're also going to have misallocated resources. So one of the problems that the regulators will have is that they're going to waste a lot of effort and time looking into what anybody who is reasonable would say are not really threatening uses of, AI, because you just have this like broad category, and so the regulators have to look into all these different things. And then finally, the last point I'd make is, from an antitrust perspective and a competition perspective, having an overbroad view of AI baked into federal policy, in particular state policy as well, is going to lead antitrust enforcers to really misunderstand these markets, because they're going to have the temptation to treat AI as a relevant market definition, or some broad subset of AI as a relevant market definition, which means that they're going to overconstrue potential competitive harms from products, goods and services, what they're going to claim is monopolistic behavior over markets that don't actually exist, but they exist in a regulatory definition.
Neil, any thoughts on that question as well, in terms of the risk of looking at AI sort of as a large group of things rather than uses? You're on mute, Neil.
AI is going to fix that for me someday. Yeah, I think the biggest risk here is, as a computer scientist, the definition of AI has been evolving over time. So when I was a kid, when I first got into computer science, the cutting edge AI technology was chess playing games. And now, your phone can play chess better than 99.9% of all humans. Things like optical character recognition, voice recognition, generating speech. All of these things were at one point cutting edge AI technologies. Now they're on our phones, recognizing objects in photos, things like that. And so the challenge with writing a definition of AI that does not sweep in all of computing is very difficult. So I think it's actually useful for legislators or people who are looking at statutes to replace the words AI with advanced computing and see if what they're talking about still makes sense. What's advanced computing today might not be advanced computing in 5 years. And so I do think that there really is an overbreadth here. There is a risk of overbreadth here. There is one particular thing with the new machine learning models that I think is very interesting, which is that the paradigm of computing has changed a little bit. And I think this is going to spread throughout a lot of what we do in computing, but it separates the sort of model, the AI model, from the AI application. And the model is a very general purpose tool. These large language models are very general purpose. And so perhaps the most general purpose technology that's ever existed. You can apply them to so many different problems. And so trying to assess like the sort of cost benefits of regulating that model is very difficult to do in the abstract. And yet we see legislators trying to set up a legislative framework for those models, even though they're very general. It'd be like saying we want a math regulation. It's like, well, yes, math can be used to, form ballistic formulas that could be used in, all sorts of weaponry, but it's also used for lots of other things. So like, how would we estimate like whether or not a math approach is safe? And so I think there is a real risk in just talking about AI in the abstract, especially at the model level, rather than talking about it at the application level, where we can look and say, like, what are the costs and benefits to regulating, say, AI in transportation or AI in certain medical devices, where we can better grapple with those trade-offs?
So kind of akin to the definition of uses of AI as being key to avoiding overregulation, there's also the question of open source versus proprietary approaches to AI systems. Andy, in TechFreedom's comments, it advocates for the AI Action Project to promote open source. Why did TechFreedom sort of take that approach?
Yeah, good question. So first of all, experts across the government and the private sector all generally agree that open source AI has a lot of benefits. It has benefits for innovation, it has benefits for competition, it has benefits for cybersecurity. So I think the first thing the AI Action Plan should do is highlight this research on the benefits of open source technologies, and again, sort of dispel these myths around open source being particularly dangerous or much more dangerous or open to manipulation or misuse than closed source models. Overall, the Cybersecurity and Infrastructure Security Agency has concluded that the marginal risk from open source as opposed to closed source models is low. And that focus on marginal risk really leads to my next and my main point that I made in the comments, which is that the AI Action Plan should implement across the federal government a marginal risk analysis framework for evaluating the risks of open source models. So what does that mean? The way that NIST, the National Institute of Standards and Technology, has explained it is that NIST recommends using a marginal risk and benefit analysis framework to weigh the additional risks and benefits of open models compared to those that come from closed models or other technologies more general. So at a high level, what the government would be doing, or the AI Action Plan would be directing the government to do, is to compare open source and closed source AI systems and ask, what can the open source models do that the closed source models can't do? Are there additional risks at the margins created by open sourcing these models? And what this approach does is it recognizes that open source technology and open source models have unique risks and benefits. and that developers should really balance these and tailor their risk mitigation strategies accordingly. And I think the entire federal government using this marginal risk analysis would go a long way towards dispelling unfounded concerns that open sourcing our models would harm US interests in AI. I think it's the opposite. Open sourcing in general would really improve the AI ecosystem domestically.
Kristian, in Iklei's comments, there was a really interesting discussion about the concern that policymakers might predicate policy actions on assumptions that are more suited to proprietary models, which has been a common model in this sort of technology space. How can policymakers avoid that kind of pitfall?
Yeah, and I'll just add on what Andy was talking about there too. It's not even just open source two points. It's not just open source foundation models. The artificial intelligence ecosystem has a number of intermediate tools that are open source projects or involve significant portions of open source projects. And to Neil's point earlier, a lot of this is just math. So if you try to regulate open source by claiming it's some sort of, it should be governed under export controls or something like that, you're quickly going to run into the math problem where a lot of this is just math, and you can see how you can restring together a bunch of these tools, which are critical to the open source ecosystem, to the general AI ecosystem, to regenerate an open source project that you would want to put under an export control. To the point, like, the example would be, look at how DeepSeek was able to refine their model with, very few resources, relatively speaking, if you credit their claims, by looking at like models that were around the world, not just in the United States. They were distilling from models released everywhere. It becomes trivial to use these tools to stand up a model. So if you're going after open source, you have to basically shut down all of open source, and then you're going to starve a lot of the software inputs into our AI competitiveness generally. And it's not a good idea. So to the proprietary question, this overlaps with the proprietary question in that if you're designing AI regulations and you're trying to create this like massive framework that contemplates, for instance, very granular levels of transparency and compliance is a requirement under these regulations, which a lot of bills try to get at. The way the EU AI Act is written tries to get at some of this. It by its nature privileges really large centralized organizations being able to do this. So almost by effect, you are disadvantaging open source, and you're saying that if you're running a project that's not able to comply with these transparency and reporting requirements, maybe you're on the wrong side of this law. What that basically says is having very distributed software projects might be a regulatory no-no. It might be a legal problem for you. So how do you avoid that? I think you avoid that to what Neil was saying and what I was talking about earlier, that you don't create these over-expansive definitions for AI, that you don't create frameworks that contemplate that they're going to sweep in the whole field of mathematical computation. You actually look for targeted harms where they might exist, and you plug the holes when you find them. A lot of this, and I'll just step back to something Andy was talking about earlier when he was talking about the history of the AI. A lot of where we find ourselves today is kind of an accident of history in a way. The early AI bills that became the EU AI Act and some of the bills you see in the state legislatures, they actually were modeled on privacy laws in the EU from the 2010s to the 2015 period that became GDPR. And that was the model that everybody was thinking about, because at that point, what people were worried about was things like civil rights violations, privacy violations. They were looking at like what would happen if the police had access to these tools to do predictive policing, or what if I forget what the other harms were, or like civil rights violations, like not renting to people because they're using these tools to do that. So like a lot of the initial regulatory apparatuses that people were conceiving was these things, and then before they could pass any of these big laws, ChatGPT released the first version of 3, which freaked everybody out. And then everyone who was sitting behind the desk writing these laws was like, oh my God, now we have to bolt something on that deals with large language models. So then the whole AI conversation around how do you regulate AI moved from how do you protect civil rights and prevent like harassing policing to how do you regulate AI? And then that sort of subsumed everything, and it kind of distorted the conversation. And then the things that we've been bolting onto these laws have increasingly been moving in the direction of, well, what we really need, like if you read between the lines, what we really need is like, and a handful of like large producers that are controlled by the state so that we can make sure they're only doing the things we want them to do. And frankly, if you look at what the Biden administration was doing, that seems to have been their policy. So it's really a breath of fresh air that we're trying to unwind a lot of that.
Thanks, Kristian. So there were quite a few comments filed with OSTP where the concept of using a regulatory sandbox was mentioned or advocated, including the one that Abundance Institute filed. Neil, how would the sandbox approach work, and how would that be beneficial in the context of developing rules for AI uses?
So first, just a little background on sandboxes. This is not an idea that's inherent to AI. Regulatory sandboxes have existed for a long time. They can apply to a wide range of both technologies, but also it could just be general business practices. And the goal is to have a sort of collaboration between the regulator and the regulated entity to enter some sort of regulatory mitigation agreement so that experimentation can go on where nobody is quite sure how the law applies right away, right, to a specific technology. And so you can see why this would be very helpful in emerging technologies. Typically a regulator will enter a sort of regulatory mitigation agreement that has conditions and promises. It might say something like, if there are violations that come out of this, or if there are some sort of technical violations of the law, we'll work through them through this process. And in exchange, you'll provide transparency about what you're doing. You'll take on these types of safeguards, even though there is no regulatory requirement that you do so. So it's a trade-off, and there can be lots of different. You can imagine there'd be lots of different frameworks that you might do this under. The one that we suggested in our comments, given that this was to OSTP and we're talking about the federal executive branch, is that there be a sort of federal interagency AI sandbox that would look across all of the federal government and offer a centralized resource, both of like the types of agreements that agencies might enter with their regulated entities, as well as common resources that could be shared across the federal government to facilitate the development of sandboxes. And the reason that we think this could be useful in the AI space is because it's such a general purpose technology. Almost every single agency is going to have some regulatory hook or some regulatory concerns, or they're going to be hearing from constituents about how AI is going to change the business for the better or the worse. And so having a centralized resource about how federal agencies can deal with this in a way that's pro-innovation, I think was our goal. I should say that in areas like AI, one of the biggest benefits of sandboxes is that you can get innovation in a space that is risky, right? Some of the areas where AI has the hugest potential are areas where people are really concerned, right? So when we're talking about like using AI for mental health or for financial advice or for, better targeting people, better enabling people to, get loans and things like that, there's lots of people are worried and the regulatory frameworks aren't perfectly clear. And so we want innovation in those spaces because the technology has a lot of promise. And if we don't offer an easy on path for that, people will just spend their time building, the next chatbot or the next meme builder instead of doing some of this stuff that could really, really address some of the significant problems that humankind faces. And so one of the best things about sandboxes, especially the best designed ones, is they're not one way, right? They're not just providing an on-ramp for the company. They're also helping the government understand what regulatory barriers are companies facing. How did they have to work through this to actually get their product to market? And then second, like what regulatory gaps are there? And so it can lead to, I think, a sort of learning lab. Utah actually has a great example of this. They have an AI bill. They just went through a recent process with a company that builds a mental health app for teens, which is, an important area. And this mitigation agreement worked out well, and it ended up with some suggested legislation to the Utah legislature, which got passed. And so I think that's a really good, successful model. And we're pretty excited for the potential that a federal regulatory sandbox could unlock for AI.
Andy, Neil mentioned what's going on in Utah, which is certainly promising. Are there any other examples at the state level or overseas in the EU that the US government might consider emulating?
Yeah, there are. If I was in charge, I would borrow bits and pieces from various state AI laws and the EU AI Act. So, as Neil mentioned, the Utah regulatory sandbox is, I think, a great success and a great model. Sandboxes are also known as safe harbors, is another term for that system. And the EU AI Act also requires regulatory sandboxes, which I think is really interesting. Some people, if you don't know much about the EU, you might think that they wouldn't want to create these frameworks which sort of exempt companies from regulation, but they actually, the EU sees the value in that sort of system, as Neil explained it. I also like some of the EU rules they have around data sanitation in terms of structuring and cleaning up data before using it to train models. The idea being that if you clean the data up nicely, you can prevent the models from becoming biased through biased training data. But I'm not a data scientist. I would want to make sure that those methods actually work to prevent bias from going into the systems without sort of unduly impacting the performance of these models. But in general, I think targeting inherent bias in AI systems is important, and the EU is pretty focused on that. And lastly, I would ban the governments from using AI for China-like authoritarian measures like mass surveillance or social credit scoring. I mean, again, those risks are not inherent to the technologies of AI, but I would maybe mention, don't use AI to supercharge these sorts of initiatives. And I'll give the EU AI Act credit again. In Article 5, they list some of these prohibited AI practices. And again, I wouldn't adopt all of those practices, but in general, I think Americans would benefit from thinking about how the government uses AI as opposed to worrying about how the private sector uses AI. I think the really high risk use cases come from governments rolling out these technologies.
So we've been talking about what's going on at the states to some extent, and while states can be a positive laboratory for democracy, if you have an avalanche of proposals like you see right now in some states, that might chill AI's growth. We'll get to the issue of preemption in a moment, but first, Neil, why does Abundance Institute, and I think some other commenters too, believe that it's critical to have that kind of leadership at the federal level, and how can that be achieved sort of to get started through the executive branch?
Well, there's a bunch of reasons. I mean, you could just start from the fundamental reason, whether at the federal or the state level, what is the right? Does it make sense to regulate AI models at the model level rather than at the application level? And I think we've already discussed that a good amount about why that's really hard to do. And so, given that states are very active in that space, I think I just checked multistate.ai. I think as of this morning, there's 983 AI regulatory proposals at the state level since January, and we'll probably get over 1,000 before the end of the state sessions. So that's a lot of activity, and so the most pragmatic reason is that, hey, if that activity isn't productive, that's going to be a big challenge for U.S. innovation. And I'd say that's so there's three reasons I think that really the federal government needs to step in here and play a big role. First is that national competitiveness, national security aspect of this technology. Obviously, the U.S. today is the best place to do AI, but China's on our heels on that, and we need a regulatory environment that's going to lean into the U.S. advantage of diverse companies trying to build new products and bring them to market. And the federal government is best positioned practically and I think legally to address this type of issue. Second, because there's a general purpose technology, I already mentioned this, and it'll impact every industry. That means pretty much every federal agency will have a touch point to AI. And so the federal government just needs to get its, message straight. There needs to be a coherent message across all of the federal agencies, all of which are going to touch AI. And so that's a really big, important role for the federal government and for the executive branch. And then third, the federal government's going to be a major purchaser and hopefully a major user of AI technology to make U.S. government better. And so they have a direct interest in making sure that the technology does what it's supposed to do, that it is innovative, that it keeps up, and that it's as innovative and capable as possible. And I think we as citizens should be interested in our federal government using AI and using it well. And so I think that that all argues for why the U.S. needs to get in there. As for how, given that in our action plan comments, we are very focused on just the executive branch. We call for essentially an anti-patchwork executive order that tries to use both the bully pulpit, but also the spending power, the discretion that the executive branch has on some of that, to encourage states to take the right steps here. That's not going to be as comprehensive a solution as, say, a federal legislative act. But I think there are lots of ways that the federal government can encourage states to take a innovation first approach that will promote the overall national interest of delivering a really high-powered and very capable AI ecosystem.
Thanks, Neil. So on the question of preemption at the legislative level, I would imagine most everybody who's watching this has been following what's going on with the creation of a national data privacy and security standard and how the issue of preemption has really made that difficult. Andy, if that's the case in the data privacy and security space, how likely is it that Congress could do it in the AI space, come up with something that creates more of a national standard rather than a state-by-state standard?
So fortunately, I'm increasingly optimistic that federal preemption could work and could actually get passed for AI policy. I've heard more discussion from lawmakers and policy wonks like us about federal preemption really in the last 3 months than the entire previous 5 years I had here at TechFreedom. Just a few months ago, the House Committee on Energy and Commerce established a privacy working group, and the privacy working group put out a request for information which explicitly asked, I'll just read the question here, how should a federal comprehensive data privacy and security law account for state-level AI frameworks? And my eyes popped out when I saw that question. I was very excited because they're really teeing up the question. And so I submitted comments answering, how should a federal comprehensive data privacy law account for state-level AI frameworks? It should preempt them. And that they're sort of begging for it. This is a committee in Congress sort of teeing up the question and begging for it. Please recommend federal preemption to us. So I think that federal preemption of AI policy is realistic and has legs, but the devil is really in the details. So, for example, what areas of AI policy will the federal government take the lead on? Which areas should they take the lead on? And which areas will be left to the states? And how can it all be done according to the Constitution and providing that we have federalism and the benefits of federalism? So I think some approaches that I've heard strike me as more realistic in the short term. That a lot of folks have recommended a regulatory moratorium on state AI laws, letting the states know, give it 6 months or a year before you pass any new AI laws, and let's all think through this a little bit more carefully. A more pie in the sky approach to federal preemption would be just sort of clean express preemption, in which Congress passes a detailed federal law explaining how exactly they want AI to be regulated, leaving sort of very little space to the states to maybe fill in some blanks. I think that's less realistic, although I think it's something we should work towards. And either way, the Trump administration's AI executive order, the AI action plan, and even statements from congressmen and senators and congresswomen sort of across the political aisle all indicate that the federal government is interested and intends to regulate AI. And I think federal preemption is a nice, clean, effective, ubiquitous tool in US law that they can use to achieve that. So I'm optimistic.
Good to hear. Kristian, any thoughts on federal preemption before we move on?
Yeah, well, my first thought is I agree violently with Andy and Neil that we need some form of federal preemption. I don't know if I'm as optimistic as Andy. I'd like to think I am, but we need it because if we have a patchwork of state laws that pull in all different directions, I think that makes it very difficult for any firm to be able to actually deploy and build products here. So like to the going back, for instance, to the open source question, where like one of the one of the ways that that gets framed is, as I said before, is like a need for export controls because it should be deemed as like some sort of I don't know if munitions is the right term, but like a regulated product that might give advantage to like foreign adversaries. Well, the truth is, all of these models are easily built in other countries, as China already demonstrated. What the competitive advantage for America is going to be is actually assembling a healthy, productive, dynamic AI application ecosystem. And the only way you're going to be able to do that is if you actually can allow new entrants to try ideas inside of the borders of the United States. But if you have 50 states with 900 bills and a bunch of them get passed and they're all pulling in different directions, the amount of startups that are going to be able to actually try to generate that application ecosystem is going to be very small. It's going to have to be a few giants that do it, and even they will be hamstrung by what they're able to do. So the patchwork of laws reduces American competitiveness on the world stage. There's nothing we're going to be able to do to stop Russia and China and everybody else from using math. What our advantage is, what our advantage has always been, is that we're an extremely innovative, dynamic country as long as we allow our people to do the thing they want to do. So that's the high level thing. To the discussion that Andy was having, I go back and forth between if I was asked what I would recommend. I think a clean federal preemption would be fantastic. I think looking at this is maybe not the right way to frame this, but I felt disappointed in the 2018 RIFO decision from the FCC, from the DC Circuit, where they said that the FCC saying that regulating under Title I, regulating common carriers, alleged common carriers under Title I was not enough if we just had a backdrop of consumer protection and antitrust. And like that's not necessarily going to be the kind of logic that every court applies when they look at this stuff. But it did give me a concern that when we're asking for preemption, if we're not asserting like a really regulatory oriented scheme, will that justify really full state preemption? I don't know for sure, but that case made me think about that. So it just gives me concern. So when I thought about that, and I thought, well, what would be a more modest one? I became one of the people that was on the moratorium side. I want more than 6 months. I probably would want like 5 years. There was the 2004 was it Space Launch Amendments Act that had a moratorium period where it sort of gave room for commercial private space launch to act. And when I was looking at that law, that seemed like a really interesting analog that we could use to try to adapt what we learned there to the AI space. So if like the federal government could pass a law, something like establishing minimum standards of being able to describe what input you're putting into your models, avoiding things like explainability, because we don't even know what Microsoft Excel does half the time, let alone ChatGPT. And being able to describe, generally speaking, like what kind of access you allow to the API, what sort of safety protocols you have inside your company, sort of minimum transparency standards. And that if we combine that with something like a research body inside of the federal government that's responsible for coordinating with federal agencies and state governments to try to gather information on where we actually see real harms emerging from the use of AI, couple that with a moratorium on contrary state regulation, I feel like that's a pretty decent middle ground that you could probably get buy-in across the political spectrum. So people feel like you're not saying you're never allowed to regulate, but we really do want a breathing period where we can see how this technology evolves.
So two more issues that we want to get to that are at least as contentious.
Sorry.
Oh, sure. Sorry. Go ahead.
Can I add something really quick on the preemption fight? Part of the challenge in the privacy space has been that there are a lot of state privacy laws now. And while there is a lot of pending legislation in the AI space, there aren't a lot of comprehensive AI laws that would be sort of preempted by this right now. The challenge in the privacy space is that the longer that goes on, the more you have legislators who sort of are defending their home turf because their home has passed a state law in this space. And so I think preemption, if we're going to have it in the AI space, needs to happen soon, or it gets harder. It gets harder the longer and the more state laws that there are.
That's an excellent point. Thanks for adding that. Two topics that we want to finish up with here. One is the president's executive order seeks AI that is, quote, free from ideological bias. Andy, how does that raise First Amendment concerns in your mind?
Sure. So, overall, the argument that TechFreedom made is that the federal government should really not attempt to define ideological bias in AI systems, because doing so, such definitions are inherently political and inherently content-based, and so therefore protected by the First Amendment. And the reasoning goes like this: the First Amendment protects individual speech just the same way it protects the speech of corporations. And AI models are the speech of these corporations or the firms that are developing them. The companies and the developers that train these models make decisions on the types of content that they want to and the types of data they use to train their models. And they rigorously define the types of responses that the models should put out in response to certain queries. And a lot of times they specifically make editorial decisions about political speech. And political speech is one of the areas of speech that is most highly protected by the First Amendment. So here at TechFreedom, we think that the way that you train your AI models is an exercise of editorial judgment that's protected by the First Amendment. And the First Amendment prevents the federal government, therefore, from defining what is ideological, what is non-ideological, what is biased, or even what an engineered social agenda would look like for an AI system. The federal government should not and cannot attempt to establish, what are acceptable, true, non-ideological outputs of AI systems. And if they attempt to, ultimately, I think they would lose those attempts under the First Amendment in courts down the road. And so that's just not the direction we think the AI action plan should go. And it should stay away from sort of trying to dictate the types of content AI models are either trained on or the types of outputs that they generate.
Neil, you want to add something on that?
Yeah. So just pragmatically, outside of the legal dimensions of the First Amendment restrictions here, we're talking about bias very broadly, and we've seen this at the state level. A lot of people are concerned about this across the political spectrum, but they're talking about very different things. That's always been the case in the social media content moderation space, where I've said it's like two people agreeing that fire is important, and one wants to build a fire extinguisher and one wants to build a flamethrower. Here in the AI space, the difference is similar in that the left is often concerned about implicit bias. Andy, you talked about this earlier. Bias that nobody intended but gets in there because the data represents the world in a certain way, and so the outcomes might reflect that representation. And the right is very often concerned with intentional bias, people trying to shape the outcomes in a specific way, the responses in a specific way. Often that shaping is done to sort of correct often for the implicit bias. And so there really is a tension here. But in the AI space, those are technically very different problems. And they happen at very different layers in the AI stack, the AI development. And so I think that this is going to be a really interesting fight in the future because the affordances to shape, say, implicit bias are much more difficult than they are to shape actual explicit bias. And you can identify that actually much easier. So I'm doing some work in this space, but I do think it's a really interesting thing to pay attention to. And I think it's important for the audience to separate out bias into several different types of way that content could be manipulated.
I'll just add on Neil's last point there. Where you're going to find hot docs is on that latter type, where the output filters, the output refinement, you're going to see if there is attempts to correct implicit bias, you'll be able to actually see like human readable code that will be looking for that implicit bias and then correcting it in another direction. So that will create a complicated public relations case.
So the second issue that I wanted to address, and this is one we could do an entire webinar on and may do at some point, is copyright protection. Kristian, in the comments that you worked on, I think that it was put very well. It says the hydraulic nature of copyright incentives is particularly salient in the context of technologies like AI, which fundamentally challenge established frameworks. How does AI challenge the existing copyright framework?
Well, yeah, that could be at least one webinar. There's a lot of material. I started, I I work a lot on copyright. I tend to be pretty enthusiastic about copyright enforcement. I'm a musician, if you can't tell, so I care about copyright. I started when AI first started coming out, and I was looking at the fair use arguments, and I was looking at existing case law. I started a little bit on the skeptical side that fair use should apply, and I've come around to the point where I think actually there's a really good case to make for fair use applying. But I'm still of the position that if you look at a variety of the cases, it's not clear that courts will apply fair use, or at least consistently. So there's going to need to probably be a legislative fix, or the Supreme Court's going to have some sort of definitive ruling on some of these key issues. So that's my table setting right there. Some of the issues that complicate the copyright discussion. One, training data complexity. The AI challenges traditional copyright frameworks because it requires access to data on an unprecedented scale, which implicates protected works in a variety of different ways. Because in that, because what we want these at least the broad LLMs to do, let's assume it's not like a small purpose specific one. The broad LLMs, we want them to mirror society. We want them to mirror the human mind. We want them to be able to think about the things we care to think about, which means they need to look at all of the open source, all the openly available things, but they also need to look at our copyrighted works in order to really adequately reflect what we want them to reflect. The problem, though, is the scale of the need, the scale of data needed for training these AIs. Even if let's assume for argument's sake that you could create some sort of pool of all of the licensors that are theoretically possible, and you can create some sort of bargaining situation between the licensors and the AI producers. The marginal value of every piece of work going into a model is so de minimis that the creators, they will not like that deal. Even if they could get the deal that you would want under traditional copyright framework, even like Stephen King's total corpus of works, which is, I don't know, worth maybe $1 billion, I don't know, hundreds of millions of dollars right now, would be worth pennies probably inside of a model. Maybe I'm exaggerating, maybe it's a couple bucks, I don't know, but it's not much because of the sheer scale of data that's necessary. And then you also have a problem where there's the relationship between those inputs that are going into the training of the model that get turned into math, basically. They're not in the models anymore. What they become is a suggestion to a model about how to relate concepts, how to relate words inside of the human, how humans think about things in various languages. Then on the output side, you could have outputs that are substantially similar to existing works and theoretically infringe on copyright law. But you could also have ones that don't, but kind of sound like, remind you of some of those inputs coming in. But there's no real good way to connect those two things in order to figure out what the monetization value is when you're trying to do that bargaining on the input. So the scale of that data really complicates traditional notions of copyright. Then there's a fair use ambiguity. So fair use, I'm not going to go into the whole thing because it's complicated. Basically, if let's say you're using a piece of copyrighted work without permission, you are technically infringing. You can then apply an affirmative defense of fair use. You have to satisfy some criteria. The one that everybody seems to be mostly focusing on is whether the work is transformative enough. And that's where I saw some ambiguity in the case law. And then, so like the problem that you're going to have there is that depending on how you're doing the training, depending on the size of your product, you may or may not qualify for fair use. So there's the Thomson Reuters versus Ross case that was decided, or there was an injunction or a motion to dismiss that was decided recently, and the judge changed his mind too. He originally thought it was not fair use, and then, or he thought it was fair use, and then changed his mind that it wasn't because of the way Ross was essentially trying to copy Westlaw by using their head notes to make a competing product with AI. So it was very focused. But even in that case, the judge was like, well, it depends on the effect on the market. So it's very complicated. It's not clear how the fair use argument is going to come out. So now to the hydraulic question you asked. So we're ambiguous on the inputs. We're ambiguous on how the law should apply. We know we want to compensate creators. That's the point of copyright, is to make sure that creators are producing innovative things and that they're being adequately compensated, so we make sure they keep producing things in the future. Because, I mean, think about it. If we were not compensating creators on these inputs, these AIs, the AIs will become useless in 10 years because you're going to basically be constantly retraining it on old stuff. It will no longer be creating new and innovative things because it needs humans to actually create the new and innovative things that it learns from in order to create more new and innovative things. So we need to figure out the compensation model. So, but you have to figure, where is the actual monetization happening in these ecosystems? The monetization is happening theoretically on the outputs of these models. It's when you go and you say, I would like to write a short story in the style of Edgar Allan Poe, right? Right now, most of these models, these commercial available ones, if you try to say in the style of or like a known name, they will say, sorry, you can't do that, because they don't want to get in trouble, understandably, under like a Lanham Act or a name, image, and likeness use or copyright or something like that. What I think needs to be done is creative people in Congress need to think about how we can maybe give an explicit fair use exemption on the training, because we need this data, but then also give creators a right that they can bargain for more strongly at the federal level on their name, image, and likeness use on the outputs, and then encourage bargaining so that artists and creators can go to the, can join unions or can go to the copyright or to go to the producers themselves and say, I would like you to be able to generate things in my likeness or in my style of. Here's what does a revenue sharing agreement look like on that? That doesn't exist right now, and I think that's what the future is, and that's that hydraulic side. We need to take away a little bit on the input. We need to give a little bit more on the output to make sure the creators are compensated.
There's really a lot to be discussed there for sure, but you really did well.
Sorry, I try to keep it
in
brief.
5 minutes. I appreciate that. So we've got some really insightful questions from our audience members, so I'd like to get to those. First one's for Neil. The focus on implementation and context is important. Thanks for your comments on that. What are your views on working to improve implementation quality and fit by looking at AI governance tools that sit at the implementation layer and working towards evidence-based standards? For example, gathering evidence on the various off-label applications of the Lammi and SHAP algorithms, which I assume you know what those are, and working based on that evidence to create standards of various contexts of use.
So Lammi and SHAP are algorithms that try to explain why an output, why a model delivered a certain output. And I think this gets to the sort of idea that we need transparency about how the process is made or how decisions are made. And I think that can make a ton of sense in certain spaces. But I think that overall, we sort of overemphasize how the usefulness of understanding how a decision was made rather than judging the decision, whether or not the decision was right or wrong. So much of, I think, what these are good at identifying is where an algorithm might be improved in the future. They don't really address and they're not the only way to do that. So one of the big advantages of AI systems is that we can ask them a bunch of questions over and over, and we can see what sort of outputs they put forth. That's harder to do in, say, human systems. So if we're talking about loan decisions, for example, you could ask a loan officer, hey, here's a set of characteristics of an applicant. Tell me how you would decide this. And, they may make decisions, knowing they're being judged for their output performance. They might make decisions based on, what they had for lunch. It's going to really vary. Whereas we can test AI in that way, not even understanding what's in the box or why, but just judge it by the output over and over through rigorous testing. And so that would be more where I would explore standard setting in this space, would be like rigorous testing, comparing inputs and outputs, rather than trying to really understand, like, well, how did this weight affect the output? That can be, I think, a very useful academic experience. But I think ultimately what we're trying to do there is, I just have some skepticism that that's going to tell us much without reducing the complexity of the system. I think the only way the most complex systems, often you don't understand how they work internally. But you can still judge them by their outputs and their inputs. And I think understanding the black box nature of this is sort of like asking, like, how do we understand the human mind? It's a very good exercise. It's important, but generally we don't. We judge people by what they do, not by not by the process by which they went through that. Yeah.
Kristian, you want to add something?
Mens rea aside, of course.
Kristian, you're on mute still.
100% agree with everything Neil said there. I just want to emphasize something. One of the problems we have with AI is that, like with this explainability one, really highlights that we believe we understand what we think about, like that we know what we ourselves are thinking about, and then we assume like, oh, well, other people do too, and then we should force AI to do that. The truth is, philosophers have known for a long time that someone will act and then they will justify it. They may not have good justifications. They may make it up on the spot. They in fact behave a lot like LLMs that are doing like predictive text of themselves about why they did the thing that they did. And it was in fact a convergence of, like Neil said, what they had for lunch, if they had an argument this morning, if they got enough sleep last night. And they are not themselves aware of why they're generating these things. And we should not hold AI systems to that standard that we know for a fact the most sophisticated creature on the planet is not itself capable of doing.
And I will add one thing. Um, I agree with all that. And in terms of the difficulty of explaining uh, the AI's actions and understanding, how AI functions, that's another reason for federal preemption. One of the benefits of federal preemption is that it puts complicated regulatory schemes in the hands of experts. States have a much harder time getting the resources together and the experts, especially for artificial intelligence, to really understand the systems and pass rules and regulations that make sense for this technology, especially with how quickly it's developing. But the federal government has way fewer of those limitations. There's lots of like NIST and regulatory agencies that can employ the best scientists, give them competitive salaries, and that's very important for improving explainability of these models. The federal government is much more capable of that than I think trying to spread that function across 50 states.
Thanks, Andy. Another question from a viewer. The new Trump OMB memo on AI, like its predecessor, Biden and Trump OMB memos, calls for agencies to conduct risk-based assessments and minimum practices for high-impact AI applications. Potential impacts include safety, privacy, rights, et cetera. Should this be a model / best practice for the private sector? That's wasn't addressed to anybody in specific. So, Andy, if you want to get us started, and then hear from Kristian and Neil.
From my understanding, I think yes. There's a good practices for the private sector. My understanding is that the private sector is these AI companies have implemented a lot of these practices sort of on their own. So it raises the question of how much this needs to be mandated, sort of at a federal or government level. But I think, of course, those are good best practices. But I'm non-technical, so perhaps I'm missing something. I'm just a lawyer.
Yeah, I'll echo Andy. From what I've talked to a lot of the AI development companies and talked to them specifically about their privacy and safety, how they go about doing that. They have sharp interests in making sure that those things are protected. Having a federal description and discussion about what's expected is probably not unreasonable. But these companies are going to do them anyway because sort of to the theme that all the three of us were talking about throughout is that there's a lot of things that are illegal in this country already, and whether you use AI to do them or not, you can get in trouble. So if you have an AI system that systematically violates people's civil rights or privacy rights or something, you will get in trouble, whether you do it with Microsoft Excel spreadsheets and advanced formulas or you do it with ChatGPT. So they don't want to violate people's rights, and they're going to try to figure it out. So what I would say, then I would caveat that by saying, to the extent that the federal framework or the federal agreement that's in place is something that is more about sort of friendly cooperation and trying to help these companies self-regulate in ways that make sense for their business model and their technology stack, that's great. To the extent that it gets developed into an onerous compliance regime by inches, I would be less supportive of that.
I'll just add that these OMB memos, there were two of them, one on procurement and the other one on the use of AI across the government. Both of them sort of reframed parallel ones that came out of the Biden administration and very much tried to streamline that process. In particular, the procurement one cut out about 30 pages of red tape that every agency would have to go through in order to, do the most basic deployment of an AI technology. And so while they kept some of the goals, which I think are good practices, I think it's just a really good example, that these practices, you can talk about risk-based assessments, minimum practices, high impact for a high impact AI, but a lot is going to depend on the details of that. And even when these make a ton of sense, and I think they do for federal deployments of AI systems, that might be something totally different if you're going to write it in regulation. Obviously, the federal government, OMB in particular, has a responsibility to make sure that the government uses this right. And that's a bit different than the regulatory authority to impose it on private actors.
Thanks, Neil. So last question, I think, is a great one to finish up with. So if the panelists were drafting the OSTP AI action plan, what 3 priorities would you include to strike a balance between innovation and regulation? Kristian, if you could go first, and the questioner also wants you to give us a guitar solo, but we're a little bit pressed for time here. So
I don't want to melt any faces. I'll refrain from doing that right now. The number one that I would put on there would be preemption. Probably number 2 and 3 would be preemption, but if I had to pick other ones as well, I would definitely push for clarifying what is meant by risk-based. So to Andy's point, if we're going to talk about risk, I want it to be a marginal risk-based framework. I don't want it to be sort of the EU's sort of ambiguous, like maybe it's a systemic risk, maybe it's not. Like we need to be very clear. We need to give companies signals about what they're allowed to develop and what they're not. And I want to err on the side of shout out to Adam Thier, permissionless innovation on producing AI. The third one, I don't know. Preemption is so high in my mind. I guess I don't know if it's something that I would definitely say you have to do, but I would put a plug in for starting to work with Congress on the copyright issue, because I think it's more likely than not, if this goes through the courts, it's my prediction, for what it's worth. It will end in a way that allows AI companies to train their data. It possibly will create disadvantages for rights holders that I think won't be positive in the future. So I would like it if Congress was really taking seriously, how are we going to compensate rights holders in a world in which their data is needed for AI?
Neil?
Yeah, so we talked a lot about the sort of, there's two parts actually of the action plan. You could say 2 domains. There's the software side, and then there's the energy side. We didn't talk at all about the energy side here. That's the software side right now, it's largely a sort of, you can build things, right? Like it's easy to build things in this space. The question is, how do we govern them? On the energy side, that is not true. It's very hard to build energy. So build new energy and connect it to the grid. So I would definitely emphasize a lot more action on that side. There are a bunch of things the federal government can do. We have some suggestions in our filing, but a bunch of things the federal government can do to release that necessary flood of energy that we'll need to really capitalize on this technology. Preemption obviously is important. The one thing I'll add, I don't know that this isn't a top priority, but we did talk about it. The federal government has a ton of data that is unstructured that could be very, very useful for training AI across a wide range of things. That data should be available. We should make that easier to get to. Obviously, we'll want to make sure there aren't privacy or security confidentiality issues, but I think there's a lot of data that the federal government holds that could be very powerful for training.
Thanks for that one, Neil. That was a really important, I think, interesting point that the Abundance Institute comment made that we didn't get a chance to get to. So I'm glad you mentioned that. Andy, as the representative from TechFreedom, our co-host, you have the last word.
I'll go quickly here. Preemption, we all seem to agree on that. I think federal regulatory sandbox is another big idea to push on that could be very helpful. And related to that, something I need to think a little bit more about is tort reform. One thing I worry about is developers of AI models being held responsible for misuse of their models via tort law. And I'm not sure if the federal AI action plan is exactly the place to explore tort reform to sort of limit the liability developers will potentially be faced with, to have it make a little bit more sense. But I think that's an area we've not talked about today, so I would mention that at the end. Throw a little curveball there at the end.
I think the plaintiff's bar moves much more quickly than even state legislators do. So that's definitely something that's worth consideration. Well, thank you everyone for joining us today. Thank you, Neil and Kristian and Andy, especially Andy, for the promotion and everything that TechFreedom put into to turn out people today. If you didn't get a chance to watch all of this, or somebody who might want to watch it, it'll be available as an on-demand file later on today. When you sign off, you'll be asked to do a real quick survey. Really appreciate you doing that if you're capable of doing that. And I imagine we'll be doing quite a bit more in this space, so stay tuned.